Professional and an associate professor of the Peter Allard School of Law at UBC. Thank you all for coming today, and welcome to the 17th annual J. Donald Mawhinney Lecture in Professional Ethics. Before we begin today's program, I want to acknowledge that UBC's campuses at Point Grey and Robson Square are situated on the traditional unceded territories of the Musqueam, Squamish, and Tsleil-Waututh First Nations. I also want to acknowledge that those of you on Zoom may be joining us today from many places, near and far, and acknowledge the traditional owners and caretakers of those lands. So before we begin, just a few housekeeping items. If you experience any technical difficulties, this is for those of you who are not in the room, please reach out via Zoom chat for assistance. I guess those in the room could also do that if you would like. Please be sure to direct your questions to the host. We have additional colleagues in the line whose webcams are turned off, but they're assisting on the back end, so we'll be able to help. Also, if you have any questions for the speaker, please use the Q&A box to submit them. Now, the Mawhinney Lecture is one of the leading lectures in Canada on the topic of legal ethics, and it allows the Allard School of Law to emphasize the critical importance of maintaining ethical standards in the legal profession. This endowed lecture was established in 2005 to recognize J. Donald Mawhinney's outstanding contributions to British Columbia's legal community, his commitment to legal education, and his dedication to practicing with the very highest of professional ethics. Mr. Mawhinney was an alumnus of the law school, graduating in 1954. He articled at Ladner Downs, now Borden Ladner Gervais, became a partner in 1959 and acted as managing partner from 1976 to 1978. In 1980, he and Howard Kello, Howard Kello, QC, established Mawhinney and Kello, and over a period of 10 years, the firm grew to 28 lawyers whose primary focus was business law. In the 1990s, the firm merged with Fraser Milner Casgrain, now Denton's, and Mr. Mawhinney served as vice chairman of the firm until 1994. Mr. Mawhinney was a firm believer in community service and served as vice chair and then chairman of University and Shaughnessy Hospitals. This lecture would not be possible without the generous support of those who contributed to the endowment and the hard work of Mr. Mawhinney's son, Mark Mawhinney, who was the driving force behind this special tribute to his father. And with that, it's my pleasure to announce and introduce tonight's speaker, Professor Andrew Martin. Professor Martin is an assistant professor in the Schulich School of Law at Dalhousie University. He holds a JD and SJD from the University of Toronto and an LLM from Georgetown. He articled at the Policy Division of the Ministry of the Attorney General, Ontario, and practiced as a law clerk and staff lawyer to the Court of Appeal for Ontario. He is also a former colleague of ours here at the law school, and it's so wonderful to have you back. His research interests include legal ethics for government lawyers and the Attorney General, as well as the application of Gladue principles in contexts other than criminal sentencing. As a person with a mental illness, he is also interested in the regulation of lawyers with disabilities. So please join me in giving a very warm welcome to Professor Andrew Martin.
Thanks very much, Graham. That's very, very kind. I'm so thankful to the Peter Allard School of Law for inviting me and to the Mawhinney family for their ongoing support for legal ethics and professionalism. It's a big deal for the Canadian legal ethics community to have this support and this recognition for what we try to do. I have a clicker. This is great. I've written about legal ethics for government lawyers for several years now, mostly in terms of doctrinal or black letter law, primarily trying to provide guidance to law societies and government lawyers, as well as governments and clients as employers. I'd like to take the opportunity here to draw together that work in a way that aims to answer in a deeper way the question I'm often asked, which is, so what, or less politely, who cares? And in doing so, I'm going to draw primarily on my own work, but also the work of others. I do want to acknowledge those who have gone before me, particularly the late Deborah McNair, for their work in this area. So I'm going to start with an introduction just to explain what I mean by government lawyers, and then talk about the three kinds of duties they have, then the interaction among those duties, and then more time than you might guess on recommendations and conclusions. So when I talk about government lawyers, I'm referring to lawyers for the federal or provincial government. These are lawyers for whom the Crown is both the client and the employer, and it's a unique client for some reasons. There are some parallels to Crown prosecutors, but when I talk about government lawyers, I'm typically not talking directly about Crown prosecutors. They have their own rich literature and case law. Some of my comments for government lawyers will apply to municipal government lawyers, but in some ways it won't. So my focus is lawyers for the province and the feds. And this matters because government lawyers are a significant proportion of the practicing bar. The Federal Department of Justice is commonly referred to as the largest firm in the country. Many lawyers will either practice as a government lawyer or interact with government lawyers. And government lawyers operate in a unique and complex practice setting. And so the high proportion of government lawyers matters as a question of legal ethics because their legal ethics are different and more complicated. And so what I'd like to do tonight is try to explain how I look at things. And I cheerfully admit that I'm very idealistic. My work has been called romantic and not in a good way. But I think what's important and what's fair, idealism aside, is that law societies need to recognize the legal implications of this complexity for government lawyers, but without torquing or lessening those obligations or expecting less of government lawyers. And likewise, government lawyers and other stakeholders should embrace this complexity while trying to maintain their professional responsibility. In my view, law societies and the Federation of Law Societies of Canada should recognize unique considerations for government lawyers, but they should do it in the codes and rules that exist already. I'm always wary of a push to make separate codes for separate groups of lawyers, whether they're government lawyers or Crown prosecutors or law clerks. For me, the rules and codes applicable to all lawyers should be amended as necessary, again, without creating special exceptions that aren't called for government lawyers. So when I talk about three kinds of duties, people more imaginative than me have called these different things. Elizabeth Sanderson talks about 3 layers of duties. Adam Dodek has the more exciting rule of law triangle. And I like Dodek's triangle because layers, with respect to Elizabeth Sanderson, layers suggest a ranking or an ordering, and that's not really the case, whereas a triangle leaves the relationship open and unfixed and complex. I will note that not unique to government lawyers is that the rules of professional conduct in the case law largely focus on lawyers as individuals and not the firm, with a few exceptions for things like conflicts of interest. And this is not a great fit for government lawyers because the public service, provincially and federally, operates as a complex tiered hierarchy in which a lawyer probably reports to a deputy director, who reports to a director, who reports to an associate deputy minister or assistant deputy minister, who reports to a deputy, who reports to the attorney general. And so this individualistic view of lawyers doesn't really fit, and I'll talk about that a little bit more. Some law societies are moving towards what's called entity regulation, which takes into account the groups in which lawyers practice. But government lawyers tend to be exempted or treated oddly under those regimes. Excuse me. So, one question people love to argue about is who the client of the government lawyer is. For my purposes, what's really important, especially when I'm talking to government lawyers themselves, which I have the joy of doing often, is the distinction between the client and the boss, that is the person to whom a lawyer reports. And the client, as an organizational client, the client is the Crown and Right of Canada or the province. And that's really important because government lawyers typically take instructions from a person in a client department, but the ultimate client is the Crown. And more importantly, as a public servant, they report to the Deputy Attorney General or the Attorney General, not the client minister or department. And that's really important for independence concerns. And again, the Federation Model Code recognizes that when there's an organizational client, the lawyer has to act for the organization, not the person from whom the lawyer takes instructions. So in terms of duties as lawyers, this one's fun because people think I'm wrong. This rule is on complete professional responsibility. And the issue is really whether this is two parts or one part. And in most contexts, this rule, a lawyer has complete professional responsibility for all business entrusted to him or her and must directly supervise staff and assistants to whom the lawyer delegates particular tasks and functions. In the case law, and I think as most people read it, this is just about supervision of non-lawyer staff. Now, it's very important because lawyers are responsible for what their staff do. But for me, there's also a broader concept of complete professional responsibility, is that as a professional with a license, you are ultimately responsible as a lawyer for what you do. And what this means, besides supervising your staff, is that you can't contract out of your ethical obligations. Part of that in a hierarchical setting is even a well-meaning manager or director or senior lawyer can't absolve a junior lawyer of responsibility for the things they do. If you picture a director saying, I know you think this is wrong, but it's my call, it's on me, that simply doesn't work with the concept of complete professional responsibility. That lawyer, regardless of what they're told to do by a superior, is putting their license on the line. We don't focus in legal ethics that much on the duty of competence. We probably should focus on it more. It's actually a relatively new duty. Amy Salzin has written at length about how until about 20, 30 years ago, there actually was no professional duty of competence per se in terms of professional regulation as opposed to negligence. The rules also talk about quality of service as including competence as well. Now, I get to sound glib because I'm in my comfy ivory tower and my government lawyer friends who are still in practice sometimes get a little grumpy at me. But this rule is really important. This is, when does a lawyer have to withdraw from a matter? Now, some of these might be obvious, like when you're discharged by the client, or coming back to competence if you're not competent to continue to handle a matter. But for me, the important one is B, if a client persists in instructing the lawyer to act contrary to professional ethics. Now, what's important here is persists. Even if the client is a lawyer, they're probably not, it's not for them to know the lawyer's professional obligations. If they say, I would like you to do X, and the lawyer says, I actually can't do X because of my professional obligations, that's fine. It's only when the client persists with this new knowledge in instructing the lawyer to act in this way that there's a problem. Graham, would you mind grabbing me some water? Sorry, it's really dry in here, folks. The rule my students most often forget on their exams is this rule, which is reporting up culminating in mandatory withdrawal. And so in addition to the mandatory withdrawal rule I mentioned on the previous slide, when working for an organization, there's an obligation to essentially report up higher and higher and higher. And then if the ultimate decision-making authority, like the board, declines to change the conduct or proposed conduct, then to withdraw. Now, this is never noisy withdrawal. This is never going to the press and saying, I am resigning because this is wrong. This is simply withdrawing. Thank you, Graham, sorry. Again, because the lawyer works for the organization, if the person who instructs the lawyer tells the lawyer, asks the lawyer to act unethically, the lawyer has to go up the chain because it's the organization that's the client. And hopefully at some point before you get to the top of the chain, someone comes to their senses and you're able to dissuade them. Again, though, this rule doesn't account for lawyers in a hierarchical practice setting, and I'll come back to that in a minute. Now, I have this bet with myself that one day I will write an academic article without citing Krieger or Adam Dodek, and it hasn't happened yet. Law societies have disciplinary jurisdiction over government lawyers. Now, I admit the reasoning in Krieger isn't as clear as it could be. That's why this Ontario Superior Court case I have here, I think, does a more concrete job of explaining why law societies have to have jurisdiction and do indeed have jurisdiction over government lawyers. But the big reason in Krieger the Supreme Court gives is that, yes, your employer can fire you, your employer can discipline you, But your employer can't stop you from practicing law in the future. Only the Law Society can do that. And so it's not enough for the government to have jurisdiction because the government can't stop the lawyer from practicing in the future. And so the Law Society has to have power and disciplinary jurisdiction over the government lawyer or crown prosecutor. There's an interesting debate in the case law, by which I mean two cases, about whether government lawyers have special or higher duties. And it hasn't been decided in BC. There's one New Brunswick case and one Ontario case. And the New Brunswick one refers to additional ethical duties imposed upon government lawyers, and then doesn't specify what those are, which is not, with respect, incredibly helpful. But it wasn't necessary to decide in that case. That brings us to Everingham, which is taught in the leading case book, and I would hope my students have at least heard of or remember the name. The divisional court in Everingham was very explicit when they said, no, there are no higher duties on government lawyers because their client and employer happens to be the government. That is, the court said very stridently, all lawyers in Ontario are subject to the same single high standard of professional conduct. In respect of their liability under the rules of professional conduct, Crown Counsel stand on exactly the same footing as every member of the bar. And so that's the layer or triangle side or vertex for duties as lawyers. The duties as delegates of the Attorney General is a little more straightforward, or straightforward to say, easier to follow. One of the things that's unique about the Attorney General and Minister of Justice is that in statute and long-established common law, they have a positive obligation to see that government affairs are conducted in accordance with the law. Now, no lawyer can assist their client in acting unlawfully, but generally speaking, unless there's some provision in the retainer, lawyers don't have a positive obligation to make sure their client acts lawfully. They may have to withdraw if the client's doing something wrong, or persists in instructing them to do something wrong, but they don't have a positive obligation like the Attorney General and Minister of Justice does. And then, since government lawyers are delegates of the Attorney General, I would argue they also have that special positive duty. What makes life trickier for government lawyers is that they're also public servants at the same time. They often have codes of values and ethics, which are usually substatutory. They have duties of loyalty and secrecy that are found in common law, statute, and those codes I just mentioned. And they have a duty to be nonpartisan and apolitical. I also should mention, and this was important to me when I was idealistic but not bitter yet, that they report to the deputy minister, not to the minister. And as a matter of public service responsibility, that's really important. So the minister or the attorney general is an elected politician, a member of the legislature or the House. It's problematic when politicians try to tell public servants to do bad things. And so that's why the deputy is the interface between the bureaucrats, in this case, the lawyers, and the minister. So those are the duties. I apologize, that was a little lengthy. It'll get more fun soon, I promise, which I tell my students every week. How do these duties interact? Well, Krieger also tells us that essentially the government can't have lower standards for their lawyers than the Law Society has. The court said it may be that in some instances, the conduct required by the Attorney General to retain employment will exceed the standards of the Law Society, but of necessity, that conduct will never be lower than that required by the Law Society. That was the Supreme Court. This is one bencher, although an esteemed bencher from Ontario, named Raj Anand. And Raj Anand, a few years ago, said it's trite law that an in-house corporate or government lawyer, or indeed an associate or partner within a private law firm, may have to choose between the direction or policy of the organization and the rules or requirements of the Law Society. Now, with the utmost of great respect to Bencher Anand, as he then was, even if that's trite law in the case of government lawyers, for which he provides no authority and for which I'm aware of no authority, I think it has to be true only on its narrowest terms. That is, a government lawyer might have to choose between government direction and policy and law society requirements. But often they're also bound by legislation. And so to expect a government lawyer to choose to follow what the law society says and breach legislation can't be the situation we're going for. And so if the rules and requirements of the law society are inconsistent with permissive legislation, the government lawyer might be free to choose what to do. More importantly, if the rules and requirements of the law society are inconsistent with obligatory legislation, the government lawyer may not have a choice. And so I want to talk about a few case studies here, not at huge length, because I don't think you'll find them as interesting as I do. But they do give some idea of how this interaction is messy. That these layers, if we call them layers or sides of the triangle, weren't designed to interlock nicely. And so sometimes the interface gets messy. And part of that is political activity legislation or policy for public servants. And so when I was a government lawyer, the legislation in Ontario said, as long as I wasn't in management, which I really wasn't, I could be politically active on my own time, as long as I wasn't using government resources or a uniform if I had a uniform. As a lawyer, I felt uncomfortable because there was something about political activity at the same level of government, either acting for or against the interests of my ultimate political masters, that made me a little uncomfortable. The legislation said I could, but my responsibilities as a lawyer, legislation not necessarily knowing I was a lawyer, just knowing I was a public servant, I felt uncomfortable. And so how do you shake this out? I think there's two answers. I think first, the fact that the government has that legislation can be understood as a waiver of the duty of loyalty. Even if it wasn't a waiver of the duty of loyalty, that legislation probably prevails as a matter of law or law society rules. What's important when we talk about the interaction between these layers and among these layers is that refraining entirely is not a good solution. Now, it's the easy solution. If I, as a lawyer and government servant, say, well, the legislation says I can be politically active, but I think that's against my obligations as a lawyer, the easy response is not to be politically active, but that doesn't necessarily comport with the best public interest or what's in the public interest. Political activity is a lot to give up. Lawyers accept limitations on their charter rights that wouldn't be justifiable for non-lawyers. Public servants accept limitations on their charter rights that wouldn't be justifiable for the general public. And so again, the answer might be complicated. What's both more and less complicated is whistleblowing. Every province and territory has, and the feds have whistleblowing legislation for public servants, which allows wrongdoing or dangerous things to be reported to someone independent of government. All the statutes say this doesn't waive solicitor-client privilege. Public service employees can report these things to an outside person, but not if it's privileged. However, the legislation doesn't mention the duty of confidentiality as a lawyer. And so what do I do if, again, because confidentiality is broader than privilege, which is a whole boring lecture I won't do tonight. What about the duty of confidentiality? Well, here again, the legislation is probably a waiver or prevails as a matter of law of the duty of confidentiality. But here again, refraining entirely is a bad solution. If I am a government lawyer and I learn of wrongdoing that if I weren't a lawyer, I would report, and I think to myself, well, I'm not sure, so I better stay safe and say nothing, that's clearly defeating the legislative goal. And so that is an easy solution, but it's not a very satisfying solution, and it's not in the public interest. I talked about the rule on reporting up a few minutes ago, and I mentioned that it doesn't account for lawyers practicing in hierarchical settings. I was an articling student with the Government of Ontario. As an articled student, I was subject to the rules of professional conduct. So if I thought the instructions I got were unlawful, according to the rules, I had to report all the way up, ultimately to the cabinet and the prime minister. I wouldn't want to have to do that. There would be no mechanism for me to do that. I can't just waltz into the cabinet room and say, stop, you can't do this. But that's what the rules seem to say I have to do. That is, the chief legal officer is the attorney general. The board, if there is a board, is cabinet. So what do? Particularly if your boss, say your director, says, no, Andrew, you're idealistic and dumb. Those instructions are fine. That doesn't remove my obligation. If my boss disagrees with me, I still, on paper, have the obligation to go as far as cabinet. Now, from a client's perspective, what's bad about this is that they might get competing advice from different lawyers. If my boss can't override me and say, no, our official position is Y, not X, if I have a duty to go to cabinet and my boss disagrees with me, the client might get conflicting advice from different lawyers because the rule applies to me as a lawyer and says, as an individual lawyer, articled student, I have to do this. Now, this is one of the occasions where my government lawyer friends kindly and politely say, Andrew, shut up. Because in reality, this never happens. In reality, there's a hierarchy and your director talks to the other director and they boot it up to cabinet if they have to, minister to minister, and then maybe it goes to the whole cabinet. But my point is the rules don't allow for that. And my thing is always, if the law or the rules don't match reality, then we have to change one or the other or both. So for my government lawyer friends to say, Andrew, that's dumb, that never happens, isn't actually an answer because we're left with this disjunct between what's supposedly supposed to happen, it's awful, purportedly supposed to happen, and what actually does happen. This is another situation, withdrawal, where my government friends politely say I'm wrong. Very kindly. I know very, very friendly people. That rule on mandatory withdrawal I mentioned says that if the client persists in instructing you to act contrary to professional ethics, you have to withdraw. Now, if you're in-house counsel or a government lawyer and your client is your employer and your only client, does withdrawal mean quitting or resigning? Now, my reality-based friends tell me no, that would never happen. Your manager wouldn't let you let that happen. Your collective association wouldn't let that happen. Something would be worked out. But the rules of professional conduct, although they say you have to withdraw from the matter, they don't say anything about whether you can then turn around and accept another matter with the same client who just told you to act unethically. And I think at a certain point, you're going to have to withdraw. If for nothing else, then you can't do your job. If you say, I can't do anything you tell me to do because it's unlawful, you're not going to have much use as an employee. And so this is a situation where government lawyers may have to consider resigning. I would say idealistically have a resignation letter in their desk ready to go. But my government lawyer friends tell me, well, that's just not right. Sometimes I write as a passive aggressive way to respond to things that are dumb. I sat through a presentation where a Crown prosecutor who opened by saying, I don't know anything about legal ethics for government lawyers, went on to talk about legal ethics for government lawyers. And he said, as a pin on at the very end, he said, and by the way, if we're underfunded, that's not our fault. And actually, for me, I think that's a problem because you can't contract out of your duty of competence. Competence isn't a duty to the client per se. It's not a duty only to the client. The client can't waive that duty. The client can't, again, say, well, how about I charge, what can you do for $50 instead of $100? If a competent job takes $100, can I pay you $50 for a subpar job? The client can't contract out of that. And that's a big access to justice issue, which is a whole other important conversation. But if you look at the case law, which is sparse, but there, especially for legal aid certificates, but in other situations, the courts and law societies have clearly said if you do an incompetent job, the fact that you weren't paid enough is not going to be an excuse. The fact that market pressures push down the price you can give for a certain service doesn't mean you're relieved of your duty of competence. And that hasn't been applied to government lawyers yet, but I don't see any way to make a principled exception. And again, although it sounds glib because I don't have to quit, there are benefits and drawbacks to being a government lawyer. A lawyer is free to accept or reject them. There's benefits to being a lawyer and there's costs to being a lawyer, and people are free to accept or reject those. And so I think, although this is the point that gets my government lawyer friends particularly grumpy at me, if a Crown Prosecutor's office, for example, is understaffed and can't meet its disclosure obligations, which is not, out of the realm of possibility, that's on them as far as the law society is concerned. Now, the practical solution is going to be different. But again, it's no defense to say, I'm a lawyer, but my client didn't give me enough money or enough resources. Again, the buck has to stop somewhere. The law society has no jurisdiction over clients. The law society only has jurisdiction over lawyers. And so in that situation, again, it's not a solution. It's not going to fix anything for the law society to try to disbar Crown prosecutors for doing their best in a bad situation. But as a matter of professional responsibility, it's still on the lawyer, although my friends disagree with me. And so what does this all mean in terms of coming back to this issue of complexity and responsibility? I think when you're a government lawyer, the most important thing to do, the first step is to ask yourself a question, because you're a lawyer, you should be able to. What does the law actually say? If there's legislation on the public service that seems to conflict with what I'm supposed to do as a lawyer, is that relevant legislation a waiver by the client of that duty? If the duty is one that the client can waive, remember, competence, I would argue, isn't one that can be waived. And if that's not the case with waiver, do the obligations as a public servant or obligations as a lawyer prevail as a matter of law? Now, provincially, I don't know which is more complicated. They're different. Provincially, that's a matter of statutory interpretation. Federally, if you're a lawyer for the feds, that's probably going to come down to paramountcy. It's actually a little bizarre, but according to the case law, the feds can choose whoever they want to be their lawyers, and the provincial law societies can't require anyone working for the feds to be licensed. So anyone could be a lawyer for the feds, as far as the case law says, regardless of their qualifications. And so for the most part, paramountcy is gonna solve that. Alan Hutchinson, who is much smarter and classier than I am, has suggested at one point that government lawyers are bureaucrats first and lawyers second. I think it would be fascinating human subject research, for which I would never get regulatory approval, to ask government lawyers, are you a lawyer first or a public servant first? I think so. The answer to that question, I think, would be very revealing. But I don't think it's that helpful if we can have a solution, as on the previous slide, as a matter of law. Now, if there isn't a legal answer, or it's unclear what the answer is, or the law seems to say the lawyer has multiple options, I would say that then we get to this question. You have to decide for yourself, are you a lawyer first or a public servant first? And there's no magic answer to that question as a principled question, unless you can honor both. If you can honor both obligations, that's great. But I think that's the point when there isn't a clear legal answer, when we have to turn to principle. And we can disagree on those. Again, I disagree with a lot of people. So what about for law societies? And I'm cautious because according to the RSVP list, there are law society folks watching. And I would never tell them what to do. But I think what's important here is for law societies as regulators to recognize the situation government lawyers are in without lessening their professional obligations. That is, law societies, again, with respect to Bencher Anand, can't expect lawyers to breach legislation on the public service. I think it would be unfortunate and publicly unpalatable and difficult to defend if the law society's position was essentially, you're a lawyer, so you have to break the law to fulfill your obligations as a lawyer. Again, provincial legislatures could amend legislation on the legal profession. If they didn't like Krieger, they actually could have changed their legislation to say the Law Society has no jurisdiction over government lawyers. And the feds can pass a bunch of laws because of paramountcy to change the obligations of their lawyers. But I don't think law societies should encourage that approach. I think they should argue against it to the extent they legitimately can. There's a could and should issue here, that politicians and legislatures could lessen the obligations of lawyers, government lawyers. I really hope they don't. And I really hope law societies don't try to do that preemptively. I mentioned Everingham before. There's this great sentence that I've never really understood. All lawyers in Ontario are subject to the same single high standard of professional conduct. That's fine. Here we go. It's not flattering to lawyers of Ontario to say that most of them are held to a lower standard of professional conduct than government lawyers. I get that intuitively. I've just always found that to be unclear legal reasoning. When my students ask me, how does that argument work? I say, I don't know. But given that the judges in Everingham are by definition smarter than me, if we flip this language, it's also not flattering to government lawyers to say that they're held to a lesser standard of conduct than all other lawyers. And so I think, again, a lawyer is a lawyer, and we have to remember that. Now, I think, and this is coming back a little bit to Krieger, governments as clients shouldn't enjoy lawyers with lesser professional obligations. That's a matter of public confidence in the legal profession. That's a matter of public confidence in the administration of justice. As I've said, there are costs to being a lawyer. I think, like many of my colleagues who teach legal ethics, I warn my students, having a law degree can be a great preparation for a life of social activism, but becoming a lawyer might constrain that. And so if you're going to become a lawyer, there's obligations that come along with the many privileges. If you're going to be a government lawyer, there's obligations and side effects that come along with that choice. And again, I know it sounds incredibly glib and rude, and I can't find a better way to say it. That choice is up to the individual. And if they don't like the calculus, then they shouldn't make that choice. Likewise, law societies should hold government lawyers to the same standard as all other lawyers, appreciating, though, that they can expect government lawyers to breach legislation to follow what the law society policy says. In terms of legislatures and parliament, every time I write about government lawyers, I worry that some minister's aide is going to read what I write, accidentally read, and say, gee, why can't we just say government lawyers are exempt from all this? Because the legislature could do that. I think it's a terrible idea. I would cry if that had been my contribution. But I think governments and legislatures should be very wary of reducing the professional obligations that government lawyers have just because they can, because I think there's going to be a large loss of public confidence in the profession and in the administration of justice. And in terms, I just want to stop with other lawyers. Again, for the many of you, well, I guess if you're not government lawyers and you don't care, you might not be here. But for the people who say, who cares, I'm not a government lawyer. Well, most of you are going to interact with one at some point, even if you don't change practice areas, which we don't all see coming. Understanding that the lawyers you're dealing with and interfacing with for the clients, that is the government, are constrained not only by the rules, but also by the law of the public service. And so appreciating that they operate in an elaborate multi-tiered hierarchy, and that things that are simple and straightforward for you to do in your practice setting are far from simple and straightforward for them to do in theirs. And I think I'll stop there. Thanks very much.
Well, thanks so much, Andrew. So we'll move now to the Q&A portion of today's event. We'll take questions from the audience and online. So remember, a reminder to the folks on Zoom, please use the Q&A function. For everybody in the room, we will have a floating mic so that those of you online can hear your question. So I'll step aside again, Andrew. And then if anyone has any questions, please feel free.
I also would be grateful if my email was flooded with comments. That's why I have it there. So if you don't have time for a question, but you have something, I often say to government lawyers, I have this great job where I have the time and ability to write about this stuff. So I would never encourage government lawyers to breach confidentiality or privilege. But if you've always said to yourself, I wish someone would write about X, then email me and maybe I will. Nikos, I think we need a mic.
Maybe not. First, thanks, Andrew, for doing this. And thank you for not only being one of the leaders in ethical issues in the legal profession in Canada, but for taking the law of ethics to new areas, government lawyers, military law, attorney general. And thank you for a fascinating talk. And I know I think this is a case you did some writing about, just because it seems to coincide with this. I'm wondering if you could talk about whether the case, I'm forgetting the name now, of the person in the Department of Justice who says wasn't acting properly with the Constitution of legislation.
Yeah, that was Edgar Schmidt.
Yeah, Edgar Schmidt. I wonder if any of the issues that were dealt with, at least in the lower courts in those cases, give any insight into the issues you're looking at.
Yeah, so just for background for people who may not be familiar, Mr. Schmidt was a lawyer for the feds. There's a provision in the Department of Justice Act that says that the Minister of Justice has to inform the House of Commons if a government bill is unconstitutional. Now, Mr. Schmidt was in whatever group made those recommendations to the minister about when the law required the minister to make that report to the House of Commons. Bizarrely, no such report has ever been made. And Mr. Schmidt, now, sometimes people blame this on the Harper government, but this is a Flavelle Martin thing too. Mr. Schmidt for years and years said, you have to make this report. The report should be made if it's more likely than not that something's unconstitutional. And the government's official position, which came up in this litigation, was no, as long as there's a 5% chance of success, it's constitutional. And as most lawyers will guess, there's pretty much a 5% chance of anything happening in court. And so these reports are never made. And so when I wrote about Mr. Schmidt, I had this dilemma because intuitively I was rooting for him. He was like this folk hero to me. But as a lawyer, I couldn't figure out how to justify what he had done, because he eventually, without quitting, basically sued the feds and went to federal court for an injunction saying that the government's interpretation of this reporting provision was wrong and Schmidt's interpretation was right. And I think the closest I could come, if I was trying to make the best argument I could on Mr. Schmidt's behalf, would be that he has duties as a delegate of the Attorney General or Minister of Justice, and I use those interchangeably, even though the feds don't always. And I think the best argument for what he did is that if the Minister of Justice or Attorney General is going to shirk their duties and not fulfill their legal obligations, then Mr. Schmidt, if that's what's happening, I'm not saying that was, then Mr. Schmidt, as a delegate of the Attorney General and Minister, had an obligation to act when the minister wouldn't. Now, I don't think that argument would be successful, but I think that's the best argument I could come up with for Mr. Schmidt. Unfortunately, Mr. Schmidt didn't get leave to the Supreme Court of Canada. So a lot of that never got resolved.
Thank you.
Our next question comes from online audience. Thanks, Andrew, for a great talk. My question revolves around federal government lawyers and honor of the Crown. Can you comment on how federal lawyers' obligations may differ in context of reconciliation and dealing with First Nations or Indigenous clients?
Yeah, that's a great question. That's an important question. Thank you. When Minister Jody Wilson-Raybould was still in office, she issued a directive about litigation involving Indigenous peoples. I think that's really important, but unfortunately, it just has the strength of a directive, which is to say that any subsequent minister could revoke it or amend it or change it. And so I think it says really important things about not taking an overly adversarial stance and being respectful in approaches and so on. I don't have the citation, but there's a case at Awapiskat out of Ontario, which I think is actually more important than the directive because it's a case. And the court says essentially, And these are provincial government lawyers for the government of Ontario. So the directive doesn't apply to them. And the court basically says, we would note that the government has taken a very adversarial approach in this case. And when the government takes an adversarial approach in litigation involving Indigenous persons, the court is going to be skeptical. And I think that's really important because I like to tell my students, even if you're a terrible person, you probably want to keep your license and not get sued. So you should pay attention in my class. In the same way, if your client is a monster, and wants to take a very offensive technical approach to litigation with Indigenous peoples, now Attawapiskat is your way of warning your client, saying, well, you could do that. But the court has clearly said that they're going to be very aware to that, and there will be consequences to those decisions. So you can say to your client, no matter who that is or what their ideological stance, these are consequences that are at risk of occurring if you take these strident positions in litigation. It's not just doing the right thing, and I wish that was enough, but it's not just doing the right thing, it's that courts are going to call us out on this. In terms of honor of the crown specifically, I think honor of the crown has to infuse everything government lawyers do, and government lawyers obviously have to educate their clients about what the honor of the crown means and how it applies. And I think, again, because the AG has a positive obligation to see that government affairs are in accordance with the law, and government lawyers are delegates at the AG, again, I think government lawyers have a positive obligation to make sure their clients are informed and appreciate what the honor of the crown means.
Are there other questions in the room?
Yes, thank you for a fascinating talk. I have never been a government lawyer, but I have been external counsel to various governments. And I now teach ethics at the law school. And so I've been what I amuse my students by calling myself outhouse counsel for governments. And one of the tensions that I recall from that experience is the impact of comms, government communications, and the impact when you're giving advice.
Yep.
So I've acted for private sector clients who have communications consultants,
right,
but never with the intensity or as central to the conversation when decisions are being made as when I was acting for government clients. And I wonder, I'd be interested in your thoughts on that, if that's one of the tensions you're thinking of that makes a government lawyer's ethical job more challenging.
I don't think it makes the legal ethics obligations any different. I think it makes it harder to live up to them. And certainly there's a temptation to buckle and let the comms people do what they're going to do because they just don't get it. But again, you're their lawyer, the government's lawyer, and it's your obligation to explain to them why what they're doing is dumb. Or, I mean, even the rules say government clients, including governments, often value lawyers' non-legal advice, right? And often have you for that reason, including external counsel. And so part of the expectation from the government is probably that you will be the, I don't want to say bad guy, but be the say to comms. My experience with government was that nothing is unlawful. It's sort of risk. It's low risk, medium risk, high risk. It's your obligation to say to the communications people, this is high risk, or this will prejudice our position in the litigation, and then escalate that if they ignore you. But I think it's one way in which, whether you're internal or external, your life becomes much harder than it would be if those comms people weren't around. But that doesn't excuse you. The fact that they're particularly diligent in being comms people, to put it nicely, doesn't absolve you of your responsibilities. I also will mention the Rothman's case out of New Brunswick that I mentioned, that said that public sector lawyers have additional duties that we won't specify. That was actually about whether, what that was about was whether when the government retains outside counsel, do those lawyers have the same obligations of in-house counsel for government? And I think that's a really fascinating question. And the short answer should be no, the obligations don't change, because if they did, then governments could simply just outsource all their legal work and get around their obligations. And that would be problematic. Does that sort of answer your question?
It does. Thank you.
We have a couple of questions online. One
Okay.
is a clarification question. The second is a broader question.
Okay.
So the first question, the clarification question is, in the beginning of your talk, you defined organization, but as you continued on, they got a bit confused. And would you be able to help clarify that specific term?
Yeah. So let me just roll back here a little bit. Actually, you know what? It's not on the deck. The rules of professional conduct refer to the situation where the client is an organization. The rules aren't particularly clear what organization means. And so the assumption generally is that that would typically mean a corporate client, but that would also include a government client, because the government is not a natural person. I don't do corporate law. I don't know if that word's right, but the government is an organizational client in the same way that a company is an organizational client.
Thank you. The second question is, we know there's a push to abolish NDAs in situations, so non-disclosure agreements, in situations of harassment and discrimination. Some provinces have legislation bringing them in. How should government lawyers respond when our superiors or clients are pushing for us to enter into an NDA with an employee where we know harassment and discrimination are present, and that NDA would remove their statutory ability to make a complaint under PIDA legislation?
That's a very good question. I will note that lawyers have a special obligation to uphold human rights law and the principles behind human rights law, and that's in the rules of professional conduct. And so that would put the lawyers in a very difficult situation. The question now, again, you're the client for the organization, not for the person demanding the NDA or the person being pressured to sign the NDA. And so you're not that person's lawyer, but you're also not the lawyer for the person pushing the NDA. You're the lawyer for the government as a whole. And so depending on what stage that legislation is at, where it goes in the future in different jurisdictions, you may be in the position to advise the person who pushing the NDA that your advice to the government as client is that is a high risk thing to push. Given that lawyers have a special obligation to uphold human rights law, I would think pretty certainly that assisting in that pressuring would definitely expose the lawyer to regulatory liability.
Thank you. I see one question in the room, and there's a mic right behind you.
Hello, Andrew.
Hello.
Thank you so much for your presentation. My name is Adam Hoffrey from Allard. There was one idea you mentioned that was quite striking to me, and that was the idea that certain legislation might have the effect of a waiver of certain government lawyers' duty of loyalty. Now, I was wondering if I even got that right.
Yeah.
I was wondering what sort of legislation do you have in mind? Because just to give a little bit of context, if legislation is to function as a waiver, that would be a very different waiver from the sort of waivers we are used to seeing in a private law fiduciary relationship. Because in private law, for one thing, waivers of duties of loyalty are frowned upon. And when they do exist and are allowed to be effective, they tend to be specific waivers given by a client or beneficiary to a specific fiduciary, whereas legislation can have much broader effect. So what type of legislation do you mean?
Thank you for the question. That's a very good question. In this respect, I'm mostly talking about legislation on the public service and public servants. Insofar as that legislation typically, so this is legislation, for example, allowing political activity or allowing whistleblowing. That legislation, although it applies to all public servants, which group includes lawyers who are public servants, that legislation rarely specifically addresses how it interacts with lawyers' obligations as lawyers. And so although it's not a waiver in the typical sense that you've described, I think that's the best way to understand it. Now, it's a bit of an odd situation because you have the legislature waiving isn't the client, the executive is the client. And so technically I'm saying the legislature is waiving something or forcing the executive's client to waive something, but maybe the executive introduced the bill anyways and supports it. And so it's not a very clean formal form of waiver. It's just, I think, the closest analogy to come to. Now, this raises the commonly asked question of whether people read things they vote on, right? And so I don't know, we might call it imputed waiver, but I don't imagine that that legislators are reading these bills saying, oh, sure, and this is a waiver of our lawyer's duties or the lawyer for the government's duties. I'm sure it's not a conscious waiver in that way. It's just, I guess, imputed or assumed is the best I can come up with.
I think we have time for one more question. Are there any other final questions in the room? Okay, Nikos.
I can't resist one more. If I teach ethics again, I gotta learn all this stuff. Andrew, I know Crown lawyers have this special core discretion that gives them a lot of flexibility, and I think it may be outside some of the powers of the Law Society. For regular government
For prosecutorial discretion.
for prosecutorial discretion,
So-
charge
so-
approval.
Yeah, so part of Krieger was really focused on whether the Law Society can discipline a Crown prosecutor.
Yeah.
And the Supreme Court said, yes, except for prosecutorial discretion.
Does that apply at all to other government lawyers? Can they claim some part of their job, and probably hard if it's not litigation based?
If you're a regulatory prosecutor, like for workplace safety or environmental stuff, you could probably claim the same. I'm not up to speed on that area of law, but I assume you probably could, but only where you're acting in a prosecutorial role.
So regular government lawyers not in
No.
that role? No,
No.
okay.
And for those of you online, I know there's a few questions that are left that we haven't had a chance to get to, but I think unfortunately we're out of time for today. So I just, please join me again in giving a really warm round of applause for Andrew. Thank you for a wonderful.
Thank you, everybody. Thank you.
A wonderful lecture and a really engaging Q&A as well. And so everybody here in the room, please feel free to join us for refreshments just outside the room. And those of you online, thank you for coming and look forward to seeing you all again soon. Thank you.
Really appreciate it.
I'm glad I wore an orange tie. We tried to color code the walls. So I called them the dance and asked them what kind of color.